Today, we're expecting the defense to rest their case after calling one final witness, forensic psychiatrist Dr. Phillip Resnick. He specializes in spotting fake mental illness claims. Once he wraps, the prosecution has 3 rebuttal witnesses. And this comes after an unexpected day in court yesterday when the judge dismissed jurors early after hearing from just one witness, hospital chaplain Sheila Kavanaugh. She testified about meeting with Lindsay around 200 times and described one of their first conversations after the murders. Kavanaugh says Lindsay told her, quote, "I am so glad my children are safe," end quote. Kavanaugh said in their meetings, Lindsay would speak about her kids and talked about hearing a voice that told her to kill her children and then herself. But the prosecution raised doubts about that testimony.
4 forensic psychiatrists sat in the same courtroom, looked at the same evidence, interviewed the same woman, and walked away with 3 different conclusions. One said she was psychotic, one said she wasn't. One agreed with part of the diagnosis, but rejected the reason behind it. And the last one, a profiler flown in from the FBI's Behavioral Analysis Unit, said flatly that she knew exactly what she was doing. That disagreement is the entire case now, not what happened. Everyone in that courtroom, including her own lawyers, agrees on what happened. The disagreement is about what was happening inside her head while it happened, and whether that difference is enough to keep a mother out of prison for the rest of her life. There's something else moving underneath this trial that almost nobody is talking about. 2 lawsuits filed quietly, months apart, by 2 people who used to be married to each other. 2 lawsuits asking the same uncomfortable question from opposite sides of a courtroom that isn't the one you've been watching. By the end of this, you'll understand why that second, quieter case might end up mattering just as much as the verdict everyone's waiting on. You already know the broad strokes. You know her name. You know what happened in that house in Duxbury. So we're not going to spend the next few minutes re-explaining a tragedy you've already sat with. We're going to go somewhere most coverage hasn't gone. Into the exact words 4 different doctors used to describe the same 11 minutes. Into a medication chart that a jury never fully got to see, explained the way it deserves. And into the question sitting at the center of that title: is Lindsay Clancy criminally responsible for what she did? 4 psychiatrists were asked that exact question, under oath, this month. Stay with this one, because their answers don't line up the way you'd expect. Here's the fast version, for anyone who needs their memory refreshed before we go deeper. On January 24, 2023, inside a home on Summer Street in Duxbury, Massachusetts, Lindsay Clancy strangled her 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan, using exercise resistance bands. She then went to a 2nd-story window and jumped, a fall that left her permanently paralyzed from the waist down. Her husband at the time, Patrick Clancy, had been out of the house running errands. He came home, found her outside, badly injured, and found their 3 children inside. He called 911 himself. Lindsay Clancy has never denied doing this. Her defense attorney, Kevin Reddington, has said as much in open court, more than once. What her legal team disputes is whether she should be held criminally responsible for it. Their argument is that she was in the grip of postpartum psychosis and bipolar disorder at the time, hearing a commanding voice she couldn't resist, and that her mind had detached from reality in a way the law recognizes as a legitimate defense. The Commonwealth's argument is the opposite. Prosecutors say this was calculated. They say she chose the moment, timed her husband's absence, and understood exactly what she was doing, and that it was wrong. She's charged with 3 counts of first-degree murder, alongside separate strangulation charges tied to the same 3 deaths. A detail that matters mainly because it shows how deliberately Massachusetts prosecutors built redundancy into this case from the start, stacking charges that all point back to the same set of facts rather than resting the entire case on a single count. If convicted, Massachusetts law leaves no room for negotiation. It's a mandatory sentence of life in prison without the possibility of parole. If the jury instead finds her not criminally responsible, she won't walk free. She'll be committed to a state psychiatric hospital instead of a prison. Those are the only 2 doors in this building. There's no hallway in between. As of this recording, the case is in its final days. The defense rested on August 21st, after weeks of testimony from more than 70 witnesses. Prosecutors have been calling rebuttal witnesses since, mostly forensic psychiatrists, working to dismantle the psychosis argument piece by piece. Closing arguments are expected any day now. When they happen, the jury will be handed a question that sounds simple and is anything but: was Lindsay Clancy in control of her mind on the day she killed her children? Before we go further, it's worth understanding exactly what that legal question means, because most people watching this trial assume it works like courtroom dramas make it look, and it doesn't. Massachusetts doesn't even use the word insanity in its courtrooms anymore. The legal term is lack of criminal responsibility, and it comes from a 1967 case called Commonwealth versus McCool. Under that standard, a person isn't criminally responsible for an act if, because of a mental disease or defect, they either couldn't appreciate that what they were doing was wrong or couldn't control their conduct even if they understood it was wrong. Notice that it's an either-or. The defense doesn't have to prove both. They only need to win one side of that test. And here's the part that surprises most people. Once a defense fairly raises the issue, the burden flips. It's not on Lindsay Clancy to prove she was insane. It's on the prosecution to prove, beyond a reasonable doubt, that she wasn't. Every psychiatrist you're about to hear from was really answering one of two narrow legal questions, dressed up in medical language. Could she tell right from wrong? And could she stop herself? To understand why 4 doctors couldn't agree on the answer, it helps to walk through that day itself, because almost every psychiatric opinion in this trial hangs off small details from these same few hours. The morning started ordinarily. Around 8 a.m., Lindsay took Cora to a doctor's appointment. By 8:30, she was back home. Patrick was there too, working from a home office in the basement, which matters, because it means for a stretch of that morning, the family was simply going through an unremarkable Tuesday. Prosecutors have pointed to what happened next as one of their strongest pieces of circumstantial evidence. In the hours that followed, they say, records show Lindsay conducting internet searches that, taken together, suggest planning rather than a sudden break from reality. The defense disputes what those searches actually prove, but the timing is part of the record now, and it's part of what the jury has to weigh. Around 5 o'clock that evening, Patrick left the house. According to testimony, he was headed out to pick up medication and the family's dinner. This is the piece of the timeline prosecutors have leaned on hardest. They allege that Lindsay used Apple Maps to track his route and estimate exactly how long she'd have alone in the house. A detail that, if the jury accepts it, cuts directly against any argument that this was an unplanned, purely psychotic episode. Surveillance footage and purchase records place Patrick at a pharmacy during this window, and then at a restaurant, picking up the family's order at roughly 5:54 p.m. None of that timeline puts him anywhere near the house when his children were killed. We'll come back to why that specific fact matters later, because a surprising number of people online have decided to ignore it. There's a smaller piece of evidence that got far less attention than the Apple Maps claim, but says something interesting about how both sides are fighting this case. At one pretrial hearing, prosecutors asked the court for permission to seek statements Patrick, along with friends and co-workers of the couple, had given to a New Yorker magazine journalist working on a profile of the family, statements describing Lindsay as, in their words, a wonderful person, an incredible mother, a lovely human being. You'd expect the defense to fight that kind of request. They didn't. Reddington told the court he'd welcome and embrace access to those same statements, because character evidence describing Lindsay as a devoted, loving mother doesn't undercut an insanity defense. If anything, it reinforces the idea that whatever happened on January 24th was a radical departure from who she actually was, not an expression of it. It's a small moment, but it tells you something about how confident the defense has been in its own framing from the very beginning. When Patrick got home, he found Lindsay outside, badly hurt from the fall. He found their 3 children inside, in the basement. He called 911 himself and told the dispatcher what had happened. From that call forward, this stopped being a private tragedy and became a public case. Lindsay Clancy wasn't formally arraigned until that October, and even then, she wasn't in a courtroom. She was arraigned from Tewksbury Hospital, where she remained under commitment. A judge at the time found she posed what the court called a serious risk of imminent self-harm, and prosecutors didn't object to that assessment. A not guilty plea was entered on her behalf. Not long after, the court ordered psychiatric evaluations, including examinations by experts chosen by the Commonwealth, and Reddington announced that the defense would be built around a lack of criminal responsibility due to mental illness. What followed was more than 2 years of delays. The trial was originally scheduled for December of 2025. It got pushed to February of 2026. Then it moved again. Every delay pulled the case further into public view, and by the time testimony actually began this year, the trial had already become something bigger than a regional news story. It was being live-streamed. It was being dissected in real time on TikTok. And it had already started drawing comparisons to earlier cases most people never expected to hear about again. It helps to know who Lindsay Clancy was before any of this, because it's part of why so many people who knew her have struggled to reconcile the woman they describe with what happened in that house. She trained as a labor and delivery nurse at Massachusetts General Hospital, one of the most competitive nursing programs in the country, and by every account colleagues have given, she was excellent at it, the kind of nurse other new mothers were lucky to get. She married Patrick in 2016. By all accounts, including from his own mother, also a nurse, Lindsay was seen as a devoted, affectionate parent who, as one family friend put it, worked twice as hard as most people to get everything right. That detail isn't in this video to generate sympathy for its own sake. It's here because it's exactly the kind of detail forensic psychiatrists have to weigh when they're trying to figure out whether a sudden, catastrophic act reflects who someone actually is, or represents a total break from it. Both sides in this trial agree on the before picture. They just disagree completely on what flipped the switch. Before we get into what the doctors actually said on the stand, it's worth understanding the condition at the center of all of it, because most people have heard the phrase postpartum psychosis without knowing how narrow and how severe it actually is. Postpartum depression, the condition most people are somewhat familiar with, affects roughly 1 in 7 women who give birth. Postpartum psychosis is a different animal entirely, and it's far rarer, closer to 1 in 1,000. It typically involves a rapid break from reality, delusions, hallucinations, extreme confusion, sometimes within days or weeks of childbirth, though clinicians who study the condition say the exact timeline can vary more than people assume. Here's the detail that matters for this case specifically. Postpartum psychosis isn't its own standalone diagnosis in the manual psychiatrists use to classify mental illness. It gets folded into broader categories, which means clinicians sometimes miss it, misname it, or argue about whether it even applies in a given case. That single gap in how the condition is classified is part of why this trial turned into a duel between experts instead of a straightforward medical finding. There's no single box to check. Every psychiatrist who evaluated Lindsay Clancy had to build their own case for what was happening in her mind, using the same raw material and reaching different conclusions. Clinically, the condition tends to move fast and look nothing like ordinary postpartum sadness. It can involve delusions, false, fixed beliefs a person can't be talked out of, alongside hallucinations, severe confusion, rapid mood swings, and in some cases, mania. It's considered a psychiatric emergency for a reason, because it escalates quickly and can become dangerous to the mother, the baby, or both, often within a matter of days. Risk factors researchers point to include a personal or family history of bipolar disorder, a previous psychotic episode, and sleep deprivation severe enough to destabilize brain chemistry on its own, something almost every parent of a newborn experiences to some degree, which is part of what makes the condition so difficult to catch early. One forensic psychiatrist, who specializes in reproductive psychiatry, speaking generally about cases like this one, rather than about Clancy specifically, has pointed out that coverage of these cases tends to default to stigmatizing language, framing it as murder versus madness, when the more accurate framing is that an under-recognized medical emergency went unrecognized until it was too late to stop. While all of this was unfolding in Plymouth Superior Court, something else was happening outside it. The live stream of the trial, carried by the Associated Press and Law and Crime, was pulling in an audience far beyond Massachusetts. Comments poured in by the thousands. Some of it was exactly what you'd expect. People processing a horrifying case, some expressing sympathy for a woman clearly suffering, some expressing none at all. but a chunk of that online reaction went somewhere stranger.
But you don't know that it was Lindsay that was actually using that computer to search. Did you know, sir, that Mr. Clancy signed in, and it was Mr. Clancy's email that accessed the Facebook account for...
A wave of amateur sleuths, concentrated heavily on TikTok, began constructing theories that Patrick Clancy, the husband who wasn't home, who has never been named a suspect, and whose whereabouts that evening are backed by pharmacy surveillance footage and a restaurant receipt, was somehow responsible instead. None of this made picking a jury simple. In a case live-streamed daily to an international audience, with online communities actively debating guilt, innocence, and increasingly, invented alternate suspects, the 12 people ultimately seated had to convince the court they could set all of that noise aside and rule only on what was presented inside the courtroom. That's always a challenge in a high-profile trial. It's a different order of challenge when the trial itself has become a piece of ongoing entertainment for millions of strangers who've already made up their minds. The scale of public attention around this case has gotten strange enough that multiple outlets now offer email and app alerts specifically for the moment a verdict comes in. A level of anticipation usually reserved for celebrity trials, not a regional murder case out of a coastal Massachusetts suburb most people outside New England had never heard of before January 2023. It's worth pausing on this because it tells you something about how true crime audiences process a tragedy that feels too senseless to sit with. A former NYPD chief who's commented on the case put it simply, everyone close to a homicide victim gets looked at until the evidence rules them out, and in Patrick's case, the evidence already has. His own attorney's legal strategy actually undercuts the theory further. If there were any real opening to shift blame onto him, a defense team fighting for a client's freedom would have taken it in a heartbeat. They haven't, because there's nothing there to take. Researchers who study conspiracy thinking point to a pattern that shows up again and again in cases like this one. When people are flooded with information about a topic but have low trust in institutions, they become far more likely to build an alternate explanation, especially when the real explanation is too painful to accept. A mother killing her own children is about as painful as it gets. So some part of the internet went looking for a different story. We're not going to spend more time on that theory, because there isn't evidence to spend it on. But we are going to spend time on where the real, documented uncertainty in this case actually lives, and that's inside the psychiatric testimony. One more thing before we get to the doctors. Kevin Reddington didn't stay a background figure in this trial. Over the course of 4 weeks, he became something closer to a public character in his own right, known for blunt, sometimes theatrical cross-examinations, and a habit of turning clinical jargon into plain, punchy language a jury and a live-stream audience could actually follow. Courtroom observers have noted he built a real following among people watching the trial online. The kind of recognizable presence true crime audiences start rooting for or against regardless of where they land on the underlying case. That matters here because a trial this technical, built almost entirely on competing psychiatric interpretations, lives or dies on whether a jury can actually follow the argument. Reddington's entire strategy, from the opening days of this trial to the final rebuttal witness, has been to keep translating 4 different medical vocabularies back into something a room full of non-doctors could hold on to. The defense's final witness was Dr. Phillip Resnick, and if you know anything about the history of postpartum psychosis in American courtrooms, his name alone tells you the defense was going all in. Resnick is a forensic psychiatrist who has evaluated or consulted on more than 80 cases involving parents accused of killing their own children. He's one of the most cited experts in the country on the subject of filicide, and in 2006, he testified for the defense in the retrial of Andrea Yates, the Texas mother who drowned her 5 children in 2001. That case ended with a finding of not guilty by reason of insanity. When Reddington put Resnick on the stand, he wasn't just calling an expert. He was calling the expert. It's worth knowing exactly what that Yates case looked like, because the parallels and the differences both matter here. Andrea Yates drowned her 5 children in a bathtub in Houston in 2001, telling authorities afterward that she believed Satan was inside her and that killing them would save them from hell. Her first trial, in 2002, ended in a murder conviction and a sentence of life in prison, a conviction that was later thrown out entirely, not because of new evidence about Yates herself, but because a prosecution psychiatrist testified that an episode of Law and Order existed showing a mother getting away with drowning her children by pleading insanity. No such episode existed. That single piece of false expert testimony was enough to unravel an entire conviction. When Yates was retried in 2006, with Resnick testifying for the defense, the jury found her not guilty by reason of insanity, and she was committed to a state mental hospital instead of prison. It's a striking historical footnote heading into the Clancy case. In the Yates trial, it was a psychiatrist's testimony, not the underlying facts, that decided which way the verdict fell. 20 years later, in a different state, under a different legal standard, 4 more psychiatrists are once again the whole ballgame. Resnick evaluated Lindsay Clancy in May of 2023, several months after the killings. He spent hours with her directly, interviewed her parents, and reviewed her medical and police records before reaching his conclusions. His diagnosis was bipolar II disorder with postpartum psychosis. On the stand, he didn't hedge. He told jurors she was, in his words, frankly psychotic on the day she killed her children. He described what he called a command hallucination, a voice she couldn't resist, layered with something he termed a delusion of influence, the sensation that an external force had taken control of her body. He put it in terms a jury could feel rather than just understand clinically. It was, he said, almost like she was a puppet and someone else was pulling the strings. He anticipated the obvious counterargument before prosecutors could even raise it. If she never told her doctors she was having thoughts of harming her children, doesn't that suggest she wasn't really experiencing what she now claims? Resnick's answer was that this kind of non-disclosure is extremely common, because parents in that situation are often terrified their children will be taken away from them if they admit what's going through their heads. He also addressed the question of whether she might have exaggerated her symptoms after the fact, for legal benefit. His read, based on psychological testing, was the opposite. If anything, he said, she showed a tendency to minimize what she'd experienced, not inflate it. And he didn't argue that she was psychotic every waking moment. That's an important distinction, because it's the kind of nuance that's easy to lose in a 30-second clip, but matters enormously in a courtroom. Just hours before the killings, Clancy built a snowman with her children. She took her daughter to a routine checkup. Resnick's argument wasn't that she'd been detached from reality all day. It was that something specific triggered a break, the command hallucination, and that once it hit, she was no longer capable of stopping herself. Prosecutor Jennifer Sprague pushed back hard in cross-examination, challenging Resnick's reasoning point by point, at one point drawing an objection sharp enough that the judge struck part of the exchange from the record entirely. The battle over Resnick's testimony was, by most accounts of that week, the most contested stretch of the entire trial. Then the defense rested, and the prosecution's rebuttal began almost immediately, with a very different doctor telling a very different story. Dr. Avram Mack, a psychiatrist who practices and teaches in Pennsylvania, interviewed Lindsay Clancy twice in April of this year. His conclusion broke sharply from Resnick's. Mack diagnosed a major depressive episode, nothing more. No bipolar disorder, no mania, no psychosis. He told jurors he saw no evidence in her records supporting the more severe diagnosis the defense had built its entire case around. When pressed on the medications and side effects Clancy had described experiencing, Mack acknowledged she likely felt something, but drew a hard line. Feeling that your body has been changed by medication, he said, isn't the same thing as psychosis. One of Mack's positions became a flashpoint in cross-examination. He defined the postpartum period, for diagnostic purposes, as the 4 weeks following childbirth. Reddington seized on that immediately, pointing out that Callan was 8 months old at the time of the killings, well outside Mack's own 4-week window, and pushing back with a line that landed hard in the room. Postpartum, Reddington argued, isn't a disease with an expiration date. Biologically, once you've given birth, you're postpartum for the rest of your life. The exchange turned combative from there. Reddington confronted Mack with prior court rulings, out of Pennsylvania, New Jersey, and Florida, where judges had criticized aspects of Mack's testimony in earlier cases, trying to convince the jury that his opinion shouldn't be taken at face value. Mack didn't back down. "I don't agree with your conceptualization," he told the defense attorney at one point, and the two went back and forth for the better part of 2 days. It's worth pausing on how differently these two doctors actually did their jobs, because the gap in methodology is almost as striking as the gap in their conclusions. Resnick spent hours face-to-face with Clancy, interviewed her parents separately, and built his opinion off nearly 3 years of distance and a wide net of collateral information. Mack met with her twice, both times in April of this year, more than 3 years after the killings, working from a narrower window of direct contact. Neither approach is inherently wrong. Forensic psychiatry doesn't have a single accepted formula for how long an evaluation needs to be, but it's exactly the kind of gap a defense attorney knows how to put in front of a jury. And Reddington did, repeatedly, trying to frame Mack's shorter, more recent contact as thinner ground to build a confident diagnosis on. If the trial had ended there, with one defense psychiatrist against one prosecution psychiatrist, it would already be a difficult case for a jury to untangle. It didn't end there. The prosecution had 2 more experts to call, and the next one nearly blew the trial up entirely. Dr. Kirk Heilbrun's testimony split the difference in a way that made things more complicated, not less. On diagnosis, he actually landed closer to the defense than to his own side. He too found evidence of bipolar II disorder. But where he broke sharply from Resnick was on the central claim holding the psychosis defense together, the command hallucination itself. Heilbrun cast real doubt on whether Clancy had genuinely experienced a hallucinated voice at all. Instead, he offered a different framework entirely, one with a clinical name, altruistic filicide. His theory was that Clancy believed she was sparing her children from suffering, that she intended to take her own life afterward, and that some part of her believed they'd be reunited afterward. He went further, telling the jury she may have believed she and the children would be together in heaven with God. That last detail is what nearly ended the trial. Heilbrun tied his theory to Clancy's Catholic upbringing, and the defense moved for a mistrial almost immediately, arguing the comment was deeply prejudicial and had no place in expert psychiatric testimony. Judge William Sullivan denied the motion, but he didn't let the comment stand either. He struck it from the record and instructed the jury, in strong terms, to disregard anything Heilbrun had said about Clancy's religious background. The theory itself matters here more than the controversy around it, though. Altruistic filicide, as a framework, doesn't argue that a parent didn't love their children or wasn't suffering. It argues something more unsettling, that within a devastating, comprehensible crisis, the choice to kill wasn't a hallucinated impulse she couldn't control, but a decision, however tragic and however sick the reasoning behind it. That distinction, hallucinated impulse versus tragic decision, might be the single most important dividing line in this entire case. Here's something almost no coverage of this trial has pointed out, and it's worth sitting with for a second. The term altruistic filicide wasn't invented by Heilbrun for this case. It was coined back in 1969 in a landmark academic paper reviewing the world literature on parents who kill their children, written by Phillip Resnick, the same Resnick who testified for the defense. In his original classification, altruistic filicide describes a parent who kills out of what Resnick called love rather than hostility, usually intending to die by suicide afterward and unwilling to leave a child behind in a world they believe is too cruel. And critically, in Resnick's own framework, that category was never defined as the opposite of psychosis. He explicitly noted it can occur either within a psychotic episode or outside one. So when Heilbrun stood up and used the phrase altruistic filicide to suggest Clancy's actions were closer to a devastating decision than a hallucinated compulsion, he was borrowing a term from the very expert testifying against him and applying it in a way its own inventor never said was mutually exclusive with genuine psychosis. That's not a detail that resolves the disagreement between these two doctors. If anything, it deepens it, and it says something about how even the vocabulary these experts share doesn't mean they're speaking the same language once they're standing in front of a jury. The Commonwealth's final witness carried a different kind of weight altogether. Dr. Gregory Sadhoff is a senior psychiatrist with the FBI's Behavioral Analysis Unit. The same unit built around profiling and understanding violent behavior at the highest level of American law enforcement. The unit whose work has shaped how investigators evaluate everything from hostage situations to mass violence. Putting him on the stand this late in the trial was a deliberate move by prosecutors. After two doctors who partially agreed with the defense, they needed someone who could speak to intent and awareness with federal-level authority behind his name. His testimony, delivered this week, was the most direct rejection of the defense's theory that any witness had offered. Sothoff told jurors that Lindsay Clancy was aware her actions were illegal at the time she committed them, and that under the legal standard Massachusetts uses, that awareness means she should be held criminally responsible. His testimony carried into a second day of cross-examination, and by the time it wrapped, the judge indicated closing arguments were close behind. So here's where that leaves the jury. 4 psychiatrists. 3 separate conclusions. Resnick says bipolar II disorder with genuine postpartum psychosis, a woman who lost control of her own mind. Mack says major depressive disorder, full stop, nothing that rises to psychosis. Heilbrun says bipolar II, like Resnick, but rejects the hallucination story in favor of a devastating, non-psychotic explanation. And Sothoff says none of the clinical debate changes the legal answer because she knew what she was doing was wrong. That's not a case with an obvious answer sitting underneath it. That's 4 trained professionals working from the same underlying facts, walking into the same courtroom, and disagreeing about what was happening inside one woman's mind during the 11 minutes that ended 3 lives. Now here's the part of this story almost nobody's telling you, and it's the reason we said earlier that a second, quieter case might matter just as much as the verdict everyone's waiting on. While the criminal trial has been playing out in Plymouth Superior Court, 2 entirely separate civil lawsuits have been moving through Norfolk Superior Court, filed by 2 people who used to share a home, a marriage, and 3 children who are no longer alive. In January of this year, Lindsay Clancy filed her own medical malpractice lawsuit, a 784-page complaint, against the psychiatric providers who treated her in the months before the killings. Her claim alleges that her providers failed to recognize what she now believes was bipolar disorder with postpartum onset, and that the medications they prescribed her didn't stabilize her condition. They worsened it, according to the complaint, to the point of contributing to a full psychotic break. Weeks earlier, Patrick Clancy had filed his own lawsuit, not against Lindsay, against the same web of clinicians and health systems. His complaint accuses her providers of over-medicating her and missing clear warning signs that she needed intensive, potentially inpatient, psychiatric care she never received. He's seeking more than $1 million in damages, and his filing represents something genuinely striking about where this case has ended up. The husband who once stood in a courtroom describing his ex-wife as a wonderful, loving mother is now formally arguing, under oath, that a chain of medical failures, not just her own actions, helped set the stage for his children's deaths. The specifics in these filings are hard to read past without stopping. According to the lawsuits, Lindsay Clancy was prescribed 9 different psychiatric medications in the months leading up to the killings. 8 of those 9 were prescribed inside a single 3-week window. Separately, court records referenced during the criminal trial show more than 30 individual prescriptions written across the 5 months before January 24, 2023, a number that captures not just how many drugs she was on, but how often her treatment plan was being changed, adjusted, and changed again. She sought help early. Records show an emergency room visit at South Shore Hospital for anxiety and insomnia, which led to prescriptions for trazodone, Prozac, Ambien, Remeron, and Klonopin, a stack of sedatives, antidepressants, and sleep medication layered on top of each other in a matter of months. Her own lawsuit also names Zoloft among the medications she says caused adverse reactions her providers failed to properly investigate. One of the named defendants is Dr. Jennifer Tufts, Clancy's primary psychiatrist, whose last appointment with her came the day before the killings. Another is Rebecca Gelada, a psychiatric nurse practitioner who testified during the criminal trial about just how frequently Clancy was reaching out for help. According to that testimony, Clancy contacted her nearly every day, asking to change her medication plan, describing intrusive thoughts, insomnia, and a kind of physical numbness she couldn't explain. She wrote to her providers about being afraid of becoming dependent on the benzodiazepines she'd been prescribed. In her own words, captured in one of those messages, "It's just a very scary, stressful time for me, and starting new meds with side effects is very scary to me." That's not the voice of someone hiding what she was going through. That's the voice of someone actively, repeatedly asking for help, in writing, in the weeks before the worst day of her life. Lindsay's malpractice lawsuit, filed by a civil attorney separate from Reddington's criminal defense team, names Astor Mental Health and South Shore Health Systems as institutional defendants, alongside individual claims of negligence, medical malpractice, and personal injury. It traces her mental health decline further back than most coverage of the criminal trial has, describing manageable anxiety after Cora's birth. Then, what the complaint calls manic behavior following Dawson's birth in 2020, an obsession with decluttering the house, racing thoughts, and a self-described pressure to constantly stay active. According to the complaint, a psychiatrist offered her an antidepressant around that time, and she declined it, worried about how it might affect breastfeeding. By the time Callan was born in 2022, the lawsuit alleges, her condition had progressed to auditory hallucinations and suicidal thoughts that she reported to her providers. At one point, she sought help at a specialized day program at Women and Infants Hospital in Providence, and was told, according to the complaint, that the program wasn't an appropriate fit for her case. That's the kind of detail that doesn't make it into a 5-minute news segment, but it maps a much longer runway of warning signs than most people following this case realize existed. Legal experts watching the civil case have pointed out why claims like these are so difficult to win, even when the medical record looks damning on its face. A health law professor at Northeastern University, speaking generally about cases like this one, explained that psychiatric malpractice claims typically hinge on convincing a jury of a very specific counterfactual, that the person wouldn't have done what they did if they'd been properly treated. Proving that kind of counterfactual about a mind in crisis is exactly as difficult as it sounds, which is part of why this second legal fight could easily take years longer to resolve than the criminal trial that's about to end. Dr. Tufts has since asked the court to convene what's called a medical malpractice tribunal, an early legal screening process unique to Massachusetts, made up of a judge, a physician from the same field, and an attorney. Their job isn't to decide guilt or liability. It's narrower than that. They decide whether Clancy has presented enough evidence for her malpractice claims to move forward at all. If the panel finds the evidence sufficient, the lawsuit continues through the normal court process. If it doesn't, the case can be dismissed before it ever reaches a jury. That tribunal process is still unfolding, separate from and largely unaffected by whatever happens in the criminal trial. Legal experts following the civil case note something important here too. While the two cases are on separate tracks, they're not entirely isolated from each other. If Lindsay Clancy is convicted in the criminal trial, that conviction could later be used to challenge her credibility in her own malpractice case, an added layer of legal complexity behind a case that already has plenty. Put those two lawsuits next to the criminal trial, and a different shape starts to emerge. This was never just one story about one woman's mental state on one afternoon. It's also a story about a healthcare system that saw a new mother spiraling in real time, changing her medications nearly every week, expressing fear and confusion in writing, and never escalated her to the kind of intensive care her family and her own lawsuit now argue she needed. Whatever this jury decides about criminal responsibility, that second question, about whether the system built to catch a crisis like this one simply didn't, isn't going away. It's the piece of this case that outlasts the verdict. It's also worth noting, because it says something about how this case has rippled outward, that hundreds of women showed up outside the courthouse during this trial. Not protesting, not taking a side on guilt or innocence, but standing there because the case had touched something personal. Fear about maternal mental health, fear about a system that might fail them too, the way they believe it failed her. That's not a detail you'll find in most of the true crime coverage of this case, and it might be the most human detail in the entire story. So where does this actually end? Different outlets covering this trial gave slightly different dates for when closing arguments would actually begin. A small discrepancy, but worth being upfront about, because it's a reminder that even now, in the trial's final days, The reporting around this case is still moving in real time. What's not in dispute is how close the end actually is. Closing arguments are expected within days of this video going up, and once they happen, the jury's task narrows down to one legal question, dressed up in complicated medical language but simple in structure. Did Lindsay Clancy understand that what she was doing was wrong, and was she capable of controlling her actions in that moment? Remember, too, that under the McCool standard we walked through earlier, it isn't Reddington's job to convince the jury Lindsay was insane beyond a reasonable doubt. It's Sprague's job to convince them, beyond a reasonable doubt, that she wasn't. That single shift in who carries the burden may end up mattering as much as anything, 4 psychiatrists said on the stand. If the jury ultimately decides the prosecution met that burden, she's guilty of first-degree murder, and Massachusetts law leaves the judge no discretion. Life in prison, without the possibility of parole. If the jury isn't convinced, she's found not criminally responsible, and instead of a prison cell, she's committed to a state psychiatric hospital, likely for a very long time, under conditions a jury doesn't control and a verdict alone won't define. Whichever way it goes, the civil lawsuits keep moving. The malpractice tribunal keeps working through its process. The questions about how postpartum psychosis gets diagnosed, dismissed, or missed entirely inside a healthcare system that hands out 9 medications in 3 weeks and calls it treatment, don't get resolved by 12 jurors reaching a verdict in Plymouth County. Those questions were already here before this trial started, and they'll still be here after it ends. 4 psychiatrists sat in that courtroom and looked at the same woman, the same records, the same 11 minutes, and reached 3 different conclusions about what was happening inside her mind. In a few days, 12 people with no medical training at all are going to have to decide which of those doctors they believe. That's the case, not who did it. Everyone already knows who did it. The only question left is whether the mind that did it was capable of stopping itself. And by the time you see this, that question may already have an answer none of us have heard yet. However the jury rules, something about this case will stay unresolved. A courtroom can decide criminal responsibility. It can't decide whether 9 prescriptions in 5 months constitutes care or catastrophe. It can't decide why a woman who was messaging her nurse practitioner almost daily, describing exactly how frightened and disoriented she felt, never got moved into the kind of intensive treatment her own family now argues, in a separate courtroom, she needed. And it can't fully explain why so much of the internet found it easier to invent a different killer than to sit with the one the evidence actually points to. Those are the questions this case leaves behind, no matter what the verdict says. The jury will answer one narrow legal question. The rest of it, the parts that actually might prevent the next version of this story, are still sitting there, unanswered, in a second courtroom nobody's live streaming. If this kind of case-by-case breakdown is useful to you, the way we did it here, following the medical record as closely as the courtroom drama, and pulling in the parts of the story other coverage skipped past, subscribe to this channel. There's still ground we haven't covered yet. The closing arguments themselves, the jury instructions, and eventually, the verdict. And we'll be breaking all of it down the same way, fact by fact, as it happens. Subscribing is the easiest way to make sure you don't miss the moment this case actually gets decided. Before you go, one last thing. Everything in this video came from courtroom testimony, court filings, and reporting from multiple established news organizations, current as of the date this was recorded. Nothing you heard here is a medical diagnosis of any real person, and it isn't a verdict. Lindsay Clancy has pleaded not guilty on the basis of a lack of criminal responsibility, and as of this recording, no jury has decided that question yet. If anything in this video hit close to home, if you've struggled with postpartum depression, postpartum psychosis, or any part of what's been described here, please know that support exists, and asking for it is not a failure. And if you or someone you care about is having thoughts of suicide, please reach out to a crisis line, a doctor, or someone you trust. You don't have to carry that alone.